And you're live.
Okay, this is House Education, Thursday, April 17th, 2025. The committee is going to learn a little bit more about the independent school approval and sort of oversight process that exists. This is a presentation probably some of us have heard previously, but part of the prompting of this is number one, there have been a couple of cases that have been in the media. We have to remember that approved independent schools also refer to what we commonly now call therapeutic schools, places where students who are on IEPs go. There was a case in Brattleboro of a school that was essentially accused of not providing the services to the students who were there. Then there was the case of the Bennington School for Girls, I think it's called. It was also recently in the news over various allegations. So it just sort of made me think this is probably something we need to learn a little bit more about, sort of how schools are approved, what the level is of oversight after that, what the role of the state board is, what the role of the agency is in all of this. Are there areas of improvement? I would just say that our witnesses are probably going to be unable to speak to any specific cases because one of the roles of the state board is to operate in a quasi-judicial fashion. And if there is a case that may be coming before them, they probably should not be speaking to it at this point. But anyway, I just think it's important that we're all grounded in how the process works, the roles of the two entities. And again, this is for all approved independent schools eligible to receive public tuition. With that, I'm going to turn it over to the chair of the State Board of Education. Welcome, and thanks for somewhat quickly preparing testimony for us. Really appreciate it.
Thank you so much. Good morning, everyone. Jennifer Deck Samuelson, chair of the State Board of Education. And to Representative Conlon's point, couple things I just wanted to get out before we start our presentation. One is, yes, I apologize. I sent everyone a slide deck, not even that long ago. The last 10 days have been rather busy for the State Board of Education, as I'm sure everyone is aware. And we had a full day meeting in Winooski yesterday, which was wonderful, but really truncated the time that I had to put something together for you guys. So I apologize. Can't say this is my most thorough presentation, but I think it will get you a good background. And then if there are additional questions, I'm happy to come back at a later point if that's helpful. And then the second thing is, as Representative Conlon mentioned, yes, this presentation will be general, talking about the rules and the process and substantive requirements, but you're exactly right. We can't speak about anything that we've seen in the paper because at this point they are allegations. These are things that may or may not come before the board, but if they do come before the board, we would be sitting in a quasi-judicial capacity, and it's important for us to remain neutral so that we are able to execute that part of our duties. So without further ado, I'm going to share my screen and bear with me. I see Tammy Colby has joined us. So Tammy, I'll turn it to you while I'm loading up my screen.
Good morning. For the record, Tammy Colby, Vice Chair of the State Board of Education. Sorry, I don't know what happened there with Zoom. So good morning, everyone.
Morning.
Just when I share my screen, when you can see the slideshow, let me know. Okay.
There we go.
Okay, so let me go to. Nope. There we go. Slideshow and from beginning. Okay. Can everyone see that?
Yes, it's perfect.
Okay, so of course I can't see you, so if there are questions, please just let me know. So the first thing I've put together is just a general flow chart that describes the process of how an independent school is approved. And this is found in State Board of Education Rules 2223 and 2224. There is a lot of information in those two rules. So it was really, I really tried to keep the tip of the iceberg in the flow chart. But I would invite the committee to really look at those rules as far as the substance that's required. And I did provide a link at the end of the slide deck for you. But basically, it starts with the agency creates an application form for independent school approval or reapprovals. This process applies to all independent schools that are seeking approval, so that includes therapeutic schools. Once the form has been created, the agency notifies independent schools of the date that its approval status will expire, and the date by which the application for reapproval is due to the secretary. Then the independent school submits its completed application to the secretary as well as its compliance assurance form. The agency then reviews the application materials. We've got a bit of a bifurcation in the rules based on whether an independent school is accredited by a third-party organization like NEASC or ASNE. It's a bit of a streamlined process if the school is accredited, and if it's not accredited, there's more work that's required by the agency, but it all leads to the same amount of information that is then subject to agency review. And the agency then submits a report, including an initial written recommendation regarding reapproval to the applicant school. The school is then given 30 days to review the recommendation and to respond. The secretary then takes any feedback from the school. You know, sometimes there are corrections made about students or courses offered. You know, there might be little things that the secretary might have gotten wrong in the report, or there might be substantive disagreements. But that would be the school's opportunity to note any objections to the proposed report. Then the secretary makes a final recommendation. The full application packet is given in the first instance to the State Board of Education's Independent School Approvals Committee, which is a 3-person committee that the board has stood up to review these. The committee then has a standing meeting where they will take in whatever requests for reapproval are currently pending. They meet with the agency, they meet with the applicant school, they go through the packet, ask their own questions, and then they come up with their own recommendation, which may be different from the secretary's recommendation. And past experience, it has been different. And then that whole thing is then given to the full board. We meet in open meeting. We review the application packet. We hear the recommendation of the chair of our Independent School Approvals Committee, discuss and then vote, and then the final decision is up to the board. Approval length may vary, and we can also put conditions on a school's approval, and we have done that in the past. So I'll go on to the next.
Fair to say, I assume that since we have a moratorium on new independent school approval, that everything is a reapproval.
Correct. At this point, everything is a reapproval. And I also want to point out that this process is much more thorough, I think, than the way it used to be. This was before I came on the board in 2020, but I know that independent school approvals and reapprovals used to be part of the board's consent agenda. So there wasn't even really an expectation that the board would really get into this and look into it independent of the agency, but we do at this point. And I think the past meetings have really borne out the board members really look into this, and we often, but don't always agree with the agency's recommendation.
A couple questions that are hanging here. Representative Long, and then
just really quickly for clarification, thank you, Jennifer. This is helpful to see this chart. You mentioned about past experience has been different. Is that what you're talking about when you just mentioned about the approval process and how? Explain the difference that you were talking about.
In terms of it being part of the board's consent agenda?
I don't know. You had said earlier that the process is different. And so then you mentioned the change that you explained, which is a surprise to me. I guess I didn't realize that it had been part of the consent agenda. It wasn't my recollection, but what is the difference that you're referring to in the past?
So that is probably one of the biggest differences, is that the agency would bring schools for the board's approval, because again, the board is ultimately in charge of approving a school's request for approval or reapproval. In years past, and I would say prior to 2020, if you look at old agenda packets, it used to, and we don't even have a consent agenda anymore, but there used to be a consent agenda where I think that was the first order of business. It might be meeting minutes from prior meetings, but then there'd be a list of schools that were up for approval or reapproval, and they would kind of be approved as a batch without really any input from the board. So that's one.
But that was prior to 2020.
Correct.
Yeah.
Correct. My point is that, you know, it not because of me, but since I've been on the board, I think the board has become much more engaged with the approval and reapproval process in ways that I think are only helpful. And then Representative Long, to your other question, I'm wondering if, because I did mention the bifurcation depending on whether a school is accredited or not. And I'm happy to kind of pull that apart a little bit more if that would be helpful.
Sure.
Okay. So this again is in State Board of Ed rule, I think it's 2224. Let me just make sure I'm saying that right. So if a school is accredited by NEASC or ASNE, what that really means is that the accrediting organization's report that it prepares for the accreditation of the school is given to the agency as part of the agency's review of the school. And it really just saves the agency the step of going to the school to conduct all of that review by the agency. If a school is not accredited, then the agency is really charged with doing that work. So going into the school, reviewing the records, making sure that things are filed properly where they should be, and that the school really, I mean, there's almost like a checklist if you go through the rules of what is required for a school to be approved. And so the agency might have to go to the school if the school is not accredited, but if the school is accredited, then the accrediting agency takes part of that. But then everything goes back to the agency to make that final recommendation that then would be completed and given to the board's independent school approvals committee.
Representative McCann had a question.
Okay.
I'm wondering about how long does the process take in like the fourth box there where the AOE is reviewing it? We had a school in this area that really felt like the AOE was sort of dragging their heels. So I'm just wondering.
Yeah, I mean, that I don't know, because that really is a question for the agency. I mean, as you can see, there are 8 boxes here. The board doesn't really come into any active part of this process until we get to the 7th box.
Okay, thank you.
Any other questions?
That's it for now. Thank you.
Sure. Okay, I'll move on. So just to basically outline the general substantive requirements for independent school approval. Independent schools seeking approval or reapproval must meet requirements of law and State Board of Ed Rule 2223, which goes through all of the requirements to operate as an approved independent school, as well as 2224, which goes through the application or reapplication for approval and the approval process by the board. The secretary shall recommend approval where the independent school provides a minimum course of study pursuant to 16 VSA section 906. As we all know, 16 VSA 906 is a pretty low bar. So the board in its most recent updates to the rules really fleshed this out. And so those requirements are really detailed in Rule 2223.3.3. With the latter two that you can see will become effective this July 1st, and those instructional strategies and curriculum content areas are really parallel provisions that the board put into 2200 that are substantively the same as what's in EQS, which is Rule Series 2000. So there's parallel provisions in both sets of rules, which was important to the board. The secretary shall also recommend approval where it finds that the school substantially complies with all statutory requirements and State Board of Education rules that apply to approved independent schools, as well as where an independent school fully complies with Rule 2223.1, which are general requirements, 2223.2, which are the non-discrimination requirements, 2223.2.1, which is the non-discrimination statement and policy, and 2223.4, which is the annual compliance assurance. In addition, if a school is seeking public tuition, it must additionally demonstrate compliance with 2229, which is the rule that was updated in response to Act 173 regarding special education approval, and 2231, which are the requirements for written agreements. I'll pause there if there are questions.
None, go right ahead.
All right.
I think at the end, there'll probably be some questions that loop back to that.
Sure. So the next, I put together sort of the cyclical requirements for the annual assurance by independent schools, and this is found in State Board of Ed Rule 2223.4. So it begins every January 15th, where the agency, in consultation with the board, creates and makes available to all approved independent schools an annual compliance assurance form. It's also required in the rule that the agency confirms receipt by each approved independent school of the form and notice of the deadline. There's a general deadline of February 15th by which independent schools must submit their completed assurance forms. I'll get to that on the next slide. The February 15th is the general rule. The form submitted by the school needs to include its specific assurance that it meets the requirements of 2223.2, which is the part pertaining to non-discrimination. And if a school wants to receive public tuition, that the school complies with 2229 and 2231, which are the two rules that I mentioned in the previous slide. The form also requires an independent school to disclose any complaints that have been filed against the school since the last time it filed the assurance form. And then schools that meet the requirements of the form remain approved for another year, and then the cycle starts all over again. And before, if there are questions, let me just...
Yeah, go ahead. Go ahead.
I'm just going to flip to the next slide because this kind of finishes out, and then maybe it'd be helpful to have questions. So
Great.
Considerations when the school misses the AOE deadline. The test that we've put in the rule, and this is Rule 2223.4, is, are there circumstances that are unforeseen or beyond a school's control that prevent submission of the form by the announced due date? If so, the school may request and the secretary may grant approval to submit the form on an alternate date. So again, this is a conversation that's happening between the school and the secretary. And then, when we get around to the announced date, whether it's February 15th or whether it's been agreed upon for a different date between the agency and the school, if the school fails to submit its form, three things happen. The secretary shall promptly contact the school regarding its deficiency. The secretary shall promptly notify the board that the school is out of compliance. And then that triggers the board's authority to revoke, suspend, or impose conditions on the school's approval status, including its ability to receive public tuition. This is one of our quasi-judicial functions where the school is provided an opportunity for a hearing. And the standard that the board has to apply is a finding that the school has failed to comply with the requirements of this subsection without a showing of good cause. I'll pause there if there are questions.
Yeah, that's great. Probably before we go into the next section about complaints and investigations. So there has been talk over the years that due to COVID, there was sort of a backlog in this process. Could you sort of speak to the status of that currently?
Yes, I will say again, this is really a question for the agency. What I can tell you, just from what I know as a member of the board, is it seems to me that the backlog really did start during COVID because schools were shut down. And again, recall that the agency is supposed to be able to go visit a school to assess certain things that are necessary for its recommendation of approval or reapproval. So during COVID, my understanding is the agency was not able to do that because schools were shut down. That started the backlog. My guess is that that backlog was probably exacerbated by a couple of things. One, we've had, as you all know, 2 rounds of updates to Rule Series 2200. So the first round was tied to Act 173, and the changes that the board implemented went into effect in May of 2022, I believe. At that point, the agency, and I have to be careful again what I say, because we're also involved in pending litigation, but just giving you the timeline, those rules went into effect in May of 2022. The agency at that point created a form that was trying to capture the updates to the rules that had gone into effect. There's now a pending lawsuit that is partially the subject of that form. And in the meantime, the board underwent a second round of updates to 2200, and these really have more to do with implementing the goals of Act 1. So the bulk of those updates went into effect last summer, and then we've got a couple that I highlighted that will go into effect July 1st of this year. So when the rules were updated the second time last year, the agents, I think that's when the agency created the technical assurance form. But all of that is to say, we can put rules into effect immediately, and we know that it's a fair assumption that our schools are paying attention, that they're trying to do the right thing, that they're trying to comply with these updates. But until the agency created this technical assurance form, there really wasn't a mechanism to capture the school's understanding of and compliance with the updates to the rules. So I know the agency worked to put this form together. I know they've sent it out, they've collected responses, and I've included again at the end a link to a memo from the agency that lays out its proposal for how it's going to deal with the backlog now that it's received the technical assurance forms back.
Do you know that again, a better question for the agency, of course, but is part of sort of the backlog a capacity issue to do the site visits that are part of the process?
I don't know that. I really don't. I do know that the people at the agency who are charged with doing the reviews of independent school requests for reapproval, I think they deal with everything involving independent schools. So whether that's developing the technical assurance form, whether that's visiting the schools, creating the report. And so I think that's a good question to ask when the agency comes in.
And then there's also an independent school is approved even if because of whatever backlog. Let's say, I know every 5 years they have to be sort of reapproved fully, and then annually have to do the assurances. But are there cases in which that 5 years passes and the school is still approved until, frankly, it isn't, right? I mean, how does that work?
So the general rule is that the school is approved until it's not approved. And I think that was probably a strategic choice that was made because you wouldn't want to penalize a school or allow, some bad actors at the agency or the State Board of Ed to sit on a school's request and then have the time go by and be like, oh, you're not approved anymore. So that the presumption is that a school is approved until it isn't. What I would say is I think this annual assurance process that's now been built into the rules and then developed by the agency based on that update to the rule really allows the board to capture on a more cyclical and reliable basis information from the schools that would allow us to know sooner than a school's reapproval period whether a school is still in compliance, and it allows the agency to recommend immediately to the board that the board take action if a school is not in compliance.
Representative Long has a question.
I'm curious about the word promptly in there. And so how is promptly interpreted? I see that in the rules and I see it on here. And what is, well, let me have you answer that first.
So promptly, I mean, again, assumes good intent. It has never been tested, because again, the agency has just received, I mean, this is sort of the maiden voyage of the annual assurance forms, and the agency has just received those responses. So we have not received any notification that a school is out of compliance, if that maybe answers or doesn't answer your question. But what I can tell you is the forms have been sent to the schools. The schools have submitted their responses. They're in the hands of the agency. And I believe, based on the memo that the agency sent to the board, the plan is to start bringing batches of schools to the board next month.
So do you know how many don't comply on time or promptly? Or
No,
whatever?
I mean,
Okay.
we wouldn't know unless the agency tells us, and the agency has not informed us that there are any concerns with schools not submitting their forms.
Okay, thanks.
Representative Brady has a question.
I'm looking at the, again, many of these questions are for the agency, but I'm looking at the
Yeah.
annual compliance assurance form, and there's links on there for schools eligible to receive public tuition, and links to further the rule 2229 and things that they have to follow. So is the only, as far as you know, the only step in terms of assuring compliance is just this self, the sort of self-attestation by schools?
Yeah, I mean, that is my understanding as well. I would double check that with the agency, but I think, based on how a school responds, it might trigger a phone call or an inquiry from the agency to follow up if things aren't matching up. And then, of course, there's always the opportunity for a complaint to be filed if a school's not in compliance.
And there are, by my really quick count, it looks like at least 75 schools eligible to receive public tuition, for which accurate attestation would be important.
Yes.
But I'm doing a quick count.
If you're looking at that memo, that sounds about right. I think there were like 50 something just general, how do I say this? Non-therapeutic independent schools
Right.
plus therapeutic schools.
All right. I'm sorry. Go ahead.
Well, I have a further question then about the therapeutic schools, because I think our committee's really interested in understanding better just the landscape of our whole system in this way, hearing repeatedly about extremely high special education costs in the state, and particularly for some of the placements, and concerns certainly by some news headlines, and I know we can't get into that, but is a therapeutic school special education program, are they treated any differently than a standard independent school receiving public tuition? Is there any sort of special education monitoring or quality assurance though? And how does that compare to what is required in public schools?
So what I'm laying out is the process that applies to all independent schools, whether or not they're therapeutic schools. But Tammy, I don't know if you want to answer the question.
Yeah, I'm happy to chime in. Good morning, everyone. So as Chair Samuelson mentioned, right, the independent school approval process is the same for whether or not a school is a therapeutic school or whether or not a regular independent school who's approved for public tuition. So the challenge there is, though, right, the therapeutic schools are essentially special education schools, right? And so we have a process where we're approving an independent school using sort of a very sort of high level set of criteria and those criteria under the rules really look at whether or not the school is prepared to serve a particular student. But our LEAs, right, are still responsible for that student, and LEAs are subject to pretty strict monitoring and accountability provisions under IDEA. Even though therapeutic schools are effectively special education schools, they are not under the current rules, right? The only way the state right now is sort of able to monitor that is through when it is the case that a particular child, when a particular LEA is undergoing monitoring by the state, and a child from that LEA is placed in a therapeutic school, then the state can check in to say, well, is that child's IEP being implemented? But the therapeutic school is not subject to the same monitoring and accountability that an LEA is for its entire special education program. So the only way that we sort of, right, so LEAs, we as a state go in because of virtue of receiving IDA funding, right? We go into LEAs, we monitor, they have compliance and things along those lines. Therapeutic schools do not undergo that same kind of monitoring. And this is actually a question that came up yesterday at the state board meeting that I asked of our state special education director. And so that could be something that you follow up with them more about, but there's a little bit of a gap here, right? Between what it is that, how we monitor special education programs within an LEA setting and versus how we monitor special education programs in therapeutic schools, which are essentially, in many cases, special education schools.
Following up on that then, so if there's an issue with a therapeutic school, I think what I'm hearing you say is that ultimately the LEA is responsible for that student getting the appropriate education. So in a sense, they're probably the on the ground sort of enforcement mechanism because they need to make sure that they're meeting the goals of the IEP. Well,
yes, right. That the interaction that comes is between the LEA and the therapeutic school, right? And as a part of the independent school approval process, certainly, there are these high level criteria, right? That any independent school needs to meet with respect to special education if they're going to take public tuition dollars. And that is, having access to a licensed special education personnel, these sort of higher level criteria. And really the criteria are set up so that they are ready to work with an LEA, right, to provide services on a student's IEP. Where the disconnect potentially happens is that we have a school, right, a therapeutic school that is effectively providing special education services to all students, right? They're operating almost as a special education school in many respects, but they're running an entire program, not just for a particular student, right? And that program is not subject to the same accountability and monitoring as an LEA's special education program is under IDA right now, right? And so we have two sets of things going on.
All right. On a different vein, part of the independent school approval process is approving the residential independent schools that we have. And to what extent is the state board and the AOE responsible for sort of the non-education part of that student's life, whether it's a therapeutic school or not? There's sort of the school day, and then there's everything beyond the school day, residential living, feeding, all of that. Does it all fall under sort of?
So independent schools who are subject to accreditation, and our chair of our independent school committee talked about this yesterday at our board meeting, right? If you are accredited by one of the major accrediting bodies, they certainly are looking at the residential component, right?
Well, and actually, let me just interrupt, Tammy, because our rules require any independent school that has a residential component must be accredited by a third-party organization.
Right. And thank you for adding that. But the accreditation process, right, goes through, right, looks at like that residential component. Jennifer, remind me though, I don't know that any of our therapeutic schools go through that accreditation process, correct?
No, some of our, well, the school I'm thinking of is not a therapeutic school. If there were a residential component, they would have to be accredited.
So I guess I don't know the answer to this question. So is the Vermont School for Girls accredited?
I don't think we can talk about specific schools.
Okay.
All right, why don't we go ahead and move on to the complaint and investigation section of the presentation.
Okay. So again, this just very high level, and I hope you all can see it because I tried to not jam up these little boxes with too much text, but basically this is the process for complaints and investigations and who's responsible at which stage of the process. So first of all, detailed complaints are made in writing to the secretary. And there has to be enough information in that complaint to show that the school substantially failed to comply with the minimum course of study, or failed to maintain resources required to meet its stated objectives, or failed to comply with statute or State Board of Education rules. So that last one is a pretty large category. From there, the secretary shall conduct a prompt initial investigation. As a general rule, and again, you kind of have to go into the rule itself to see how this all plays out. But in general, the school receives notice, and the secretary also makes an initial determination of whether the matter can be resolved through informal means. And we've talked to the agency about this before, and maybe there was some administrative hiccup and things didn't get reported, and that could be something that's brought to the secretary's attention, and staff could, work through whatever that issue is with the school and resolve it at that point. That would never come before the board. It's just kind of a little hiccup in the school's operation that gets resolved, by the agency, and that's the end of the matter. However, if the agency offers technical assistance that the school doesn't follow, or if the secretary determines that a formal investigation is required given the nature of the allegations in the complaint, the secretary may place the school on probation, and at that point would notify the State Board of Education of that action. The school has a right to appeal the imposition of probation to the board, and again, this would come before the board in our quasi-judicial capacity. But whether or not the secretary places the school on probation, the secretary, if there's a formal investigation, would appoint a review team. The review team conducts a school visit and performs an assessment of the allegations. The review team then informs the secretary and the school of the results of that visit and assessment, and the school is included on the agency's register of complaints, which is a public page on the agency website that lists schools that are on probation or have had suspension or revocation of their approval status. From there, the secretary shares its findings with the Council of Independent Schools, and then the council considers the findings from the investigation and the secretary's proposed resolution, and it issues a written opinion.
I'm going to interrupt for a second. I'm not sure I've heard of the Council of Independent
Yeah.
Schools.
So that is created, I believe, in statute. And let me just 2226, because I did sort of trim that language down. So this, I'm reading 2226.2.2A4. If the secretary determines that a formal investigation is warranted, the secretary shall appoint a review team of at least 2 persons that, with the consent of the school, shall include a member of the Council of Independent Schools. Does that answer your question?
I guess I'm wondering who makes up the Council of Independent Schools?
So
It's a body that I hadn't heard of before, that's all.
I feel like they were created in statute, but I'm not 100% positive on that. I can track that information down and get back to you.
Okay, great, yeah. And I assume probably nothing's reached this point, so therefore it's never been activated, at least in memory.
Well, certainly not since I've been on the board. I do know that there have been complaints and investigations of independent schools for sure.
Yeah.
So continuing on, this is the 6th box. The secretary determines whether revocation or suspension of approval is appropriate. And if so, at that point, the secretary notifies the State Board of Education and school. Excuse me. So again, this is kind of where the State Board of Ed comes into the process, in the 7th box, where we provide an opportunity for a hearing as we sit in our quasi-judicial capacity to consider the secretary's recommendation. So, we would have the Agency of Education as one party and the school as the other party, and the board would render its decision on the matter. And then pursuant to rule, the State Board of Education may revoke, suspend, or impose conditions on a school's approval status, including its eligibility to receive public tuition, if it determines that the school has failed to demonstrate that it has the required resources to meet its stated objectives, failed to comply with statute or State Board of Education rules, failed to report a financial event that's listed in the rule, or failed to make an annual enrollment report to the secretary. So I will pause there if there are questions.
Not seeing any.
I can ask
Oh,
a
yeah, I'm
question.
sorry.
In looking at that flow chart, the 4 bullet points about what kind of complaints would trigger this investigation, it's limited to only those 3 types of complaints.
Correct. That is what's listed in the rule, but as you know, there are many statutes that pertain to approval of independent schools, as well as our State Board of Education rules themselves are pretty voluminous. And when we did the most recent round of updates to 2200, we listed out a lot of those statutory requirements, just so that it was clear to schools. And then we also impose a continuing obligation to make sure that they're apprised of any new statutory obligations that might come into effect. Shall I go on?
Yeah, we're on to the next slide then, I think.
Okay. So this is just kind of a conclusion here that the board's role in this is limited to adopting rules for approval, which we've done. We make findings before approving schools that meet the requirements of Title 16 and our rules upon recommendation of the secretary. And when appropriate, we conduct quasi-judicial due process hearings to revoke or suspend independent school approval, again, upon recommendation of the secretary. And then finally, at the end here, I linked some resources for you. So again, I mentioned that the rules are pretty detailed in terms of requirements for approval, and listed out the pages if you want to hone in on 2223, 2224, 2226. And then I also included a link to the AOE annual compliance assurance form and put the tip there. If it doesn't look like much until you actually start, pretending that you're a school and clicking on responses, and then based on responses, additional things will pop up. And they also hyperlinked the rule. So if you're certifying compliance with rule, whatever it is, there's a pop-up that will allow a school to see what that rule is before they click on the box or not. And then I also included the memo that was submitted to the board in March, which is the agency management plan for addressing the backlog.
Great. Why don't you go ahead and stop sharing your screen? Yeah. So these resources are really helpful, and thank you for providing them in addition to the rest of the testimony. Look forward to looking through them. Anything further that you would like to add before I ask if there's any final round of questions?
Not for me.
Thanks. I think what was very important for the committee, excuse me, is sorry, may need to take over. Is understanding the roles of the AOE and the state board, and sort of the somewhat limited role the state board has when it just comes to the general oversight and all of that. When you have talked about complaints being filed about a school, I'm assuming that means complaints filed either to an LEA, perhaps in the case of a therapeutic school, or to the Agency of Education. Are those the main routes for complaints?
Yes. So the complaint, pursuant to our rules, would have to be filed with the secretary to start that whole process that's laid out in rule. Now, you could imagine that there might be other violations, say, of statute, and that would implicate DCF or something like that. And I didn't put that in my slide presentation. It is in the rules themselves that, if there's a complaint that's filed that implicates DCF, that DCF would also be notified, and DCF would also then conduct its investigation of the underlying allegations.
Yeah, maybe you could talk a little bit more about sort of where DCF might play a role versus where the Agency of Education plays a role.
I would say you might want to follow up with the agency on that. But I do know that, for instance, therapeutic schools have a requirement, like DCF has a requirement to visit therapeutic schools in a way that they don't a non-therapeutic independent school.
That's interesting. Other questions, committee? Great. Well, thank you again for kind of getting us grounded at a high level in all of this. And we'll continue to probably spend some time with the agency to get a better sense of their role in all this as well.
Great.
All right. Thanks very much.
Thank you all.
Committee.